Wait for the YouTube to work. All right, we should be good to go if we want to start. Because we are recording it and it is on YouTube. They can catch up on the discussion after they join.
Okay. Jeff, are we going to do introductions like last time, or does everybody know everybody?
Yeah, we'll do some introductions. We'll go around. We do have the zoning staff that is on here, so we'll go around with the zoning staff. So the BZA members, so you guys can get a name or a face to the individuals.
Do we need to call roll to make, says this is a?
Yep, it's a special meeting, so we're
Yep.
going to open the meeting and do the normal tap dance.
Jerry, you got to open the meeting.
I'm sorry?
You want to open the meeting?
Yes, this is the meeting for March 4th for training for the Zoning Board of Appeals on ethics. And if you would, Jeff, call roll.
Mr. Miller,
Yes?
Mr. Oster,
Yes.
Mr. Shipley,
Yes.
Mr. Treves will be late. Miss Sundar,
Yes.
Mr. Rife,
Yes.
and then our Mr. Boyd is not on at this time either. We'll start with introducing members from the township staff or the zoning staff. With what roles we do and areas. We can start. Nancy, do you want to start?
Sure. I'm Nancy. I am the zoning assistant. I make sure all the meetings are on the zoning report and get that posted on the website. I get the legal notice ready and get that sent.
It's okay, go ahead.
In the great minutes.
That's it.
You
Yeah,
can't
Nancy.
stroke us a check or anything like that.
Yeah. Nancy is one of our newest members to the zoning team. She's been with the township for a while on the administrative side, but we had her join the zoning department last summer, fall time. So we're excited to have her as the township is growing and we could use all the help we could get. So thanks for being here. I guess I'll go. My name's Michelle Bonney, the Development and Zoning Director of the Township. I know everybody here, but just thought I'd say hello again. And my title was recently changed this past fall as the Township trustees have asked us to focus on some more economic development opportunities in the Township. So I will be leaning my focus more on that. But as far as BZA's roles go for me, I believe I'm the support and backup for Jeff as he takes lead in all the BZA applications. And if there's anything ever controversial, I like to be present, especially if there's a large attendance, help moderate those meetings for him. So I think Jeff does a really good job as far as putting the materials together. So I kind of let him run the show, but I'm here if needed. So thanks for having me.
And Cindy, are you on?
I am. I'm Cindy Davis, and I try and figure out what everybody's saying at the meetings and put it down on paper, and then you guys get to look at it and tell me what I've said wrong.
You do a
You
great
do a
job.
good job.
Thank you. Thank you. I appreciate that.
Next will be our zoning intern, Brett.
Hello, I'm Brett Wimkin. I'm the planning and zoning intern here. I'm a senior at the Ohio State University studying city planning and architecture. And as far as BZA stuff related, just kind of help put the packet materials together and help out anywhere I can.
Then I'm Jeff Beard with the senior zoning officer. I've met all of the BZA members. I'm in charge of getting all the information, reviewing all the applications for the BZA, for the variances, conditional uses. I have Nancy and Brett help with getting letters sent out to the surrounding areas of the applications. And then we put the packets together, get them delivered, and then for the most part, I host most of the meetings, unless something comes up and Michelle has to cover for me. And then other than that, I do the enforcement for the township and also review signage permits, along with compliances for new builds. And that is our zoning staff, at least at this point in time.
A lot bigger than what it was 4 or 5 years ago. Where it was one person.
Yep.
Yeah, I did a lot in 1 year. I was also finishing my master's program, so I don't know how I did it, quite honestly. But I'm happy to have a staff, and we are well equipped today. And I guess the segue with that, we recently partnered with Pete Griggs and his firm as our new legal counsel. And we did hold a zoning commission training last week that we thought went really well. In fact, we might even have another one in the nearby future, as the dialogue was just overall really, really good conversation. And, you know, Jerry and Jeff, if you're ready for Pete to start, I think we can get going.
Let's get going.
And David did join. I saw that. So
Yes,
just for the record.
Yep.
Good. Well, I've kind of know you guys a little bit. I sat in on the church variances and conditional use, and which I think is really good because it kind of gave me a really good understanding of how you guys operate. And the one thing that I've learned in the past 20 years of doing this is everybody's different. And it's not my goal to come in and change the way that you do things. It's just simply to provide you with the information, the tools necessary to have your decisions upheld in the event that your decisions get appealed. And you know, my mentor Don Brocious always used to say, if there's one body in the township that's going to get sued sooner or later, it's the BZA. And that's just by virtue of what you do. And for me, this is probably my favorite part of my practice, is representing BZAs and defending their decisions. And, you know, I've not had a BZA case get to the Supreme Court yet, but quite a few Court of Appeal cases. And it's just, it's really fun because I don't get into court a lot, and this is about as close as I can get to being a kind of a trial attorney, if you will. But I'm gonna try to keep it a little bit shorter than I did with the zoning commission. So if there's a takeaway from tonight, and some of you, you know, this may be repetitive for some of you, I want you to understand your role in the grand scheme of zoning. So understanding your role is one thing I want you to take away. And the other thing that I want you to take away from this is to be able to rationalize your decisions. I think if you know those two things, you're ahead of the curve, and I don't think you're going to have any issues. So with that said, I'm not going to go over a lot of this introductory material because I think that's probably more important from a zoning commission standpoint. But overall, our zoning and township zoning is confined to Ohio Revised Code 519. That's kind of our Bible, if you will, and what we have to look at in terms of our authority and our power. And there's two big limitations on those powers. One is a constitutional limitation. You don't really see that at the BZA level. That typically happens at the zoning commission and trustees levels with rezonings. But I've had a few occasions where I've had appeals from a zoning inspector determination where they argue in front of the BZA that the code is unconstitutional. And there are a few cases out there that basically says the BZA has no authority to decide constitutional issues. So if you ever get in a situation where an applicant's arguing constitutionality of our code and what we're doing, you don't have the authority to decide that. They need to appeal. They need to take that to a higher court. So that's all I really want to say on the constitutional issue. It's really should never be an issue in front of you.
If I can ask a quick question.
Sure.
Under D, it's zoning is an exercise of police power.
Correct.
And I'm not trying to be one to pick apart wording, but from a policing power, that would be under Jeff, for an example, as enforcement of the zoning laws. That wouldn't necessarily be the BZA being a police power.
Correct. That's just, Jerry, that's a good point. And everybody feel free to chime in as we go along. It's just the police power is just, I guess you'd say globally zoning, but not our ability to exercise that function is a police power, just because you don't have to have zoning. And there's probably a third of the state that's not zoned. So you're right. It's not necessarily the BZA itself, but it's just the zoning and making the decision to zone and have zoning in place is a overall police power.
Okay.
So the other area, the other quick limitation that I'm just going to hit on briefly is what we're going to call statutory limitations. And because it's a police power, the state gives us that power. We have to look at 519, and there's a bunch of limitations on what townships can do. We're not like cities. So I have a bunch of those listed out. And again, where I typically see a BZA getting involved in some of these is on appeals. So the zoning inspector will make a determination, whether or not something's a non-conforming use or structure, or whether or not something is agriculture or not agriculture. And a party in interest has the ability to appeal that decision to the Board of Zoning Appeals. So you may be in a situation where you are trying to apply or make a determination, one of our statutory limitations under 519. And I have those, listed out, and those could be training sessions in and of themselves. So I just want you to know that those exist. There's lawful non-conforming use limitation. There's an agriculture limitation. There are farm market limitations. There are cell tower limitations, public utility limitations. One big thing that we're seeing here in the last year or so, really not applicable to you guys, but wind farms and solar farms are huge. Solar farms in particular are in the last year and a half are cropping up everywhere. But I guess the good news for Orange Township is the land is too valuable. So most of the solar and wind farms are being gobbled up in rural areas. But all those limitations, I think where the BZA could play a role is, again, if a decision is appealed from the zoning inspector. Example, Liberty Township, right next door, the zoning inspector made a determination that a structure was related to agriculture. The neighboring property owner appealed that determination. BZA had to make a decision as to whether it was or not. And then that went to the Court of Common Pleas, and the court said it was ag. Then it went to the Court of Appeals, and the Court of Appeals said it was ag. So that's where I see you really playing a role in the statutory limitations. And if we ever get to that situation, certainly, we'll get down into the nitty gritty of what those limitations are and try to provide that guidance. But really just wanted to point out that there are limitations. On the bottom of page 3, the creation and function of the Board of Zoning Appeals. And this is probably, Jerry, gets to more of your question on the police powers. But what you do as a BZA, when you hear an appeal, a variance, and a conditional use permit, is you are acting in a quasi-judicial capacity. And that is extremely important. So if you look at the big picture of zoning, the BZA acts as a quasi-judicial body. The Zoning Commission acts as a legislative body. And knowing that role, knowing that you're acting in a quasi-judicial capacity is going to tell you certain things. So it's going to tell you that, all right, my decisions that I make as a board are subject to a direct appeal to the Court of Common Pleas. Okay. Now, Zoning Commission is just the opposite. There's no direct appeal. Their decisions and the trustees' decisions may be subject to a referendum, but there's no direct right of appeal. It's going to tell me as a member of the body, when I'm acting as a quasi-judicial capacity, that I should not have what we call ex parte communications with applicants. So in other words, can an applicant pick up the phone and call me and say, hey, Jerry or Rick or anybody else, what do you think about my application? The answer is absolutely not. It's completely inappropriate. Different answer with the Zoning Commission or the trustees when they're doing a rezoning. It's because it's a legislative function. The other thing it's going to tell me is, do I have the ability to meet privately, to consider an application in front of me? And when I'm acting in a quasi-judicial capacity, the answer is yes. Yes, I do. I have the ability to recess during a hearing and discuss the merits of the application in private. Right? All the decisions have to be made in public during the open session, but I have that ability. Different answer for Zoning Commission. The answer is absolutely not. Everything's got to be on the record. Everything's got to be in the open. All conversations that occur between commission members have to be open during an open session. The last thing it's going to tell me when I'm acting in a quasi-judicial capacity is that I have to run my meeting and I have to check all the formalities. So I have to be pretty formal. Now, I want to stop there for a second because I consider myself to be a very practical person. And I understand that 99.9% of the time, what you're considering in front of you is pretty kind of mundane stuff, and the likelihood of it being appealed is slim. So, you know, what I want you to understand is when you have that case, when you see an attorney, I was going to say walk in the room, and I think we're going to be getting back to that. Or when, you know, Jeff says, hey guys, we're getting all kinds of people, you know, emailing and sending letters in. I want you to be able to really grab the reins and be able to run a really tight ship in a real formal hearing. And we'll get into that. But really, quasi-judicial, that's your function. So what does quasi-judicial mean? It means you're acting like judges. That's what you guys are. You guys are judges. You're interpreting the code. You're making interpretations of the code, right? If someone appeals Jeff or Michelle's decision, you have to interpret the code and render a decision. When someone files a variance or a conditional use, you're applying their facts to the law. And the law is A, your code, and B, the variance cases that the Supreme Court has set forth on use and area variances. So that's your role. Real quick on private deliberations. Again, that's a Supreme Court case. It's also a 5th District Court of Appeals case, which covers Orange Township. 5th District does. So you're good to go on that. Typically, how that would happen is, let's say you get through everything, and you know, the staff goes, applicant goes. You kind of ask questions. You've had public comment. At that point in time, if you guys want to kind of take a step back and discuss it amongst yourself, somebody simply makes a motion to recess into private deliberations for the purpose of conducting the merits of the application. Second, roll call. And then let's say we're in person, then you can physically go to another room and talk about where we're headed. I mean, what are your thoughts? I mean, is this a thumbs up? This is a thumbs down? What conditions do we want to put on the on an approval? How do we want to justify our decision? And it's not uncommon for members to scribble out their motion that they're going to make on a piece of paper, and then go out, and then you come back, you reconvene, and then you render a decision.
Pete, if we act as a quasi-judicial and we make a motion to meet in private,
Mm-hmm.
the entity that's filing for that BZA application, would they not complain that they don't have the right to either question or apply their
Attend? You mean
yeah.
attend?
No, not
Be involved?
They're not able to try to further convince the board of what their needs are.
So yeah, so Jerry, good point, and they do. And this 5th District Court of Appeals, that was the argument that the attorneys made, and the court basically said no. I mean, it's a Supreme Court case that we have to rely on, and remember, we don't let the prosecutor or the defense attorney, or in a civil case, both attorneys go back while the judge is trying to formulate his decision and have that and have them influence the judge. I mean, that's their chance when we're in open meeting to influence and to provide testimony and evidence to you. So that, Jerry, they do, but at the end of the day, the courts have upheld BZA's ability to do that.
Okay.
But they do complain. Now you could come back out and when you're back there, you could say, what about this issue? I mean, we haven't really heard anything about, about property values. Let's ask the applicant or the next door neighbor if he's actually got any type of documents that it will decrease the property value of his home, or does he have an appraisal or anything, so you can come back out and continue the discussion if you need additional information. But they can complain all they want. It's our ability. And once again, something I don't recommend that you do on every case, on every application, but I think it's those ones where it's really complicated and you have a lot of people and you have a lot of attorneys. It's nice to take a step back and be able to sit down and chat about it.
Okay.
Mhm. And so that's just going to be the quorum and you that would attend a deliberation.
Yeah, it could be. Yeah, you can have counsel back there. Jeff and Michelle should not come back. In a variance proceeding, Jeff and Michelle are actually considered adverse parties. Conditional use, it's kind of, there's really no case law on it. On an appeal, most definite, they're an adverse party. I've had it happen once after the fact where we were brought in and we spent, hours writing a brief that the BZA wasn't biased because the zoning inspector came back in. So our advice is staff stays out of that. That's a good point, Rick.
Yeah, I kind of read through this before the meeting and it seemed pretty clear that would pretty much just be us and you.
Yep. And, even if, because I'm not going to be there all the time. And if you guys just, if an attorney shows up, and you guys just don't feel comfortable, go ahead and, use it yourself. So, attorney doesn't have to be present either, but attorney and board members, I believe, is really all that should be back there.
Yeah, well, that makes sense. And I always kind of thought that we should have been doing that from time to time, but we never really, I don't think we ever really have. I think there was one case where we did take a break and do that a little.
Yeah,
we didn't go to a room and actually discuss it, take notes and all that. So I don't think we've actually really went to a private deliberation.
We have not done that since I've been a part of the board. We did take a break during the late night. So, but we haven't actually taken a break and had a discussion about it.
Yes. Yeah.
So if we have questions that either the applicant or Michelle or Jeff can answer, we have to go back into session, ask that question?
Yes.
Okay.
Yep, that's exactly the way it's done. Yep. So again, just know that it's there. Know that you have that kind of safety net if you need a breather. And again, you guys know this. The decision itself has to be in open session.
Mm-hmm.
I have next on this kind of training document, I have rules governing organizational meetings. You guys kind of have a semblance of rules of procedure in the zoning resolution itself. I've given Michelle and Jeff samples of other places. Typically, I like to see it as a separate document and not in the zoning resolution. And that's something that we can go, maybe hit down the line when we have more time. But for the most part, you're required by law to have them. And I think the argument would be that your code itself provides for those rules of procedure. Jurisdiction. This kind of gets into the nitty gritty of what you do. And so we talked about appeals, right? And all these things are quasi-judicial. We talked about appeals. Let's say Jeff or Michelle issue a permit or deny a permit. All right, somebody has 20 days to appeal that decision. And it happens. I know it may not have happened here yet. An interpretation of a code, how a fence is measured, is it from the grade, the type of fencing that's permitted, an ag exemption, all those things can be appealed. Obviously, you guys know variances is the second broad category, two types, and we'll go into them a little bit in a minute. Use and area. Third major area is conditional use permits. The fourth major area is variances or conditional uses for the extraction of minerals. I don't know how often you have that. Doesn't happen very often, at least my experience. And I don't believe your code provides for a conditional use permit for surface mining. That's kind of a relatively new area of the law, and I'm not sure there's much in Orange Township anyway. But that's the jurisdiction. That's the statutory jurisdiction of the BZA. The one thing I will note is outside of a variance or conditional use certificate for the extraction of minerals, the BZA in your code needs to be changed with respect to conditional uses. The BZA has no authority to revoke a permit, or once you issue a variance or a conditional use, the BZA has no authority to revoke it.
You must have found out Calvin has diamonds under his house.
Well, if he does, I think that's where we should hold the next meeting. So, but you have no authority to revoke a permit. So what happens is once you make a decision, once you grant a variance, once you grant a conditional use, that in essence becomes the zoning for that particular property or issue. And then Jeff and Michelle would simply pursue it as a zoning violation. So they would send a notice of zoning violation. And obviously that would have the potential to be taken to court if necessary. But there are times where I've seen the BZAs revoke a variance, and you can't do that. And that's a relatively recent case that was decided a couple years ago down in Pickaway County.
With that said, Pete, does the conditional use still, if the owner changes hands, do they have to seek another conditional use, or like if
do you? And I've looked through the code and I don't remember. Do we in our code? Do we state that in our code?
Yeah, typically that's what they do. Like they've had an issue with churches where a church changed hands and that church didn't get the conditional use, but the other one had the conditional use.
We've had it a few times on stuff, and well, we were always under the impression that once that person that got the conditional use changed hands to somebody else, his variances didn't automatically go to the next guy.
Yeah. So let's say, and I'm just throwing a hypothetical out there. Let's say that I have a conditional use that allows for a trucking company. So Pete Gregg's trucking company comes in, gets my conditional use, but then I sell it to, Smith Trucking Company. My personal preference is that I think the conditional use and I think there's a very good legal argument. I think that conditional use continues with the new owner.
Well, and with that said, it's not necessarily that we're going to say, well, no, you can't do the same thing at that location. It's just they would have to apply and get the variance again.
Yeah, so, I mean,
On an
typically,
ownership change.
yeah, typically, unless your code says otherwise, or you have a really good reason, the typical rule of thumb is variances and conditional uses run with the property.
So it's basically a lifetime deal.
Could be now, but if I change it, if I'm a new owner and I change it, then I think I have to come back in and modify my variance or modify my conditional use permit.
We've had some issues though, where somebody's owned property for 50, 60, 70 years and sells it, and the new owner is in violation of whatever, because at the time of the original scenario, there was no zoning laws for Orange Township. So that's come up.
So I'm trying to think of that, Jerry, in the context of a variance. So I own
It could
property
be a use variance, for an example.
for a what?
It could be a use variance.
Right.
I
so
think we had that come up in the old original Lewis Center where
Yeah.
there was no variances given. It was just very odd in every respect. And now the new people have to come in before BZA.
Are we talking about the Unitarian
Yeah.
church?
No, it's
Well, I think
it's
we
the
had some
house.
businesses in there too.
Right.
Yeah.
Yeah.
It's
Wait.
our code states in the legal non-conforming uses that if they expand or like do an addition or something, they have to get a conditional use through the BZA.
Mm-hmm.
And
So if
old
the
Lewis
sign
Center-
changes, even
Yeah,
if
well,
the say the monument sign is going to be in the same spot,
Yep.
in the same size and everything, but it's going to change names and everything, they would have to come back in and redo that.
So if you are making it, so when you approve a variance or conditional use and you make it site specific, or application specific, I don't necessarily disagree with you, but going back to the non-conforming issue. So the High Revised Code provides that townships are required by law to they must allow for the extension and reasonable extension or modification of lawful non-conforming uses. And typically the entity that does that is the BZA. So if I am a lawful non-conforming use, that means that what I was doing was lawful before the code existed or before the code was changed. And now I sell it, and a new owner wants to come in and wants to extend or somehow modify that, then absolutely they got to come in front of the BZA and show what they're doing differently. But what happens if I'm not doing anything differently? Am I extending or am I modifying it all? And the only thing that has changed is a piece of paper and maybe the legal entity that's operating it.
I think both of those concepts, they relate to what we did. One was the addition of the front monument or the design element, and then the second one was the sign. So
yeah. So if there's changes,
and of course, a monument sign always has to be looked at for, how many colors and, the type and, and all that stuff anyway, but.
Right, Rick. And so if let's just say I issue a monument sign and I approve it as submitted, and then we sell, I sell it to somebody else and they come in and they any way, shape or form want to change that, what we've approved, then they're going to have to come back in front of you. I agree with all that, but let's take the example of, let's just take the swimming pool that was up in front of you and the application was withdrawn. Let's say you approve that variance and they put in a swimming pool. So you mean to tell me when I sell my house, the new person has to come back in and get another variance?
No.
If they change their
Because-
fencing,
Right. So I think that
Yeah, if they change something. Yeah.
right. So that's what I mean when the variance or the conditional use runs with the land, not the person.
Mhm.
The exception to that is if the new person, or really when you think about it, the existing person who was approved, if any way they want to change anything that you guys have approved, they're going to have to come back in front of you.
Mhm.
And there might be sections of our zoning resolution that we'll want to clean up to clarify that a little better. I think it's, especially with the conditional use part, it's a bit confusing to read. So
Yeah, so I think we're all on the same page, and I agree with you guys. If there's any change to what you have approved, I think they have to come back in front of you. But just because a property changes hands and has new ownership doesn't necessarily mean that they have to come in and get a new conditional use or a variance.
So if the property just changes hands, and I'll use your trucking company example, they're
Mhm.
doing a trucking company, then we don't need to see it.
No, but let's say they want to change the monument sign, or they want to, add another building. Maybe they're gonna.
Right.
That's where they're gonna pull their trucks in to fix them. Then I think they're gonna have to come in and get a modification to what you previously approved.
but if that trucking company is sold and the monument sign would be changed only with the name of the trucking company, the font size, the color of the fonts, the color of the amount of color of the signs and all that, they're still gonna have to
Yes.
come, if they're changing the sign.
Yes. So they'll have
Yes.
they'll have to redo for the sign. But I think what he's saying is, say another trucking company comes in there and now he wants to do maintenance work in, one of the buildings or in one side of the building, that may be different than the last guy just used it for storage. It just depends on what they're really doing there.
Correct.
And what they're changing.
Correct.
Okay.
It's not necessarily, oh, okay, well, you're blanketed in just because you're a trucking company or whatever. Sometimes you're going to have to look at, okay, well, what is going to go on in there?
That's exactly right, Rick.
We had a landscape company apply to use their garage as a garage for their company at their house.
Mm-hmm.
Mm-hmm.
And the neighbors were claiming that the property values are going to go down based upon all the traffic and whatever else might be going on in there.
Mm-hmm.
That's what came before us, and that is a change, I guess.
Yeah.
Okay.
Yep. So just to understand that distinction, but typically variances, conditional uses run with the land. Obviously, if they change, then they're going to have to come back in and get in front of you for that review. So on 5, I have appeals. Again, we've talked a little bit about what it means. An appeal can be taken by any person who's aggrieved by Michelle or Jeff's decision. They have 20 days from the date that they make that decision. One of the things I want to make sure that Jeff and Michelle do is whenever, particularly with violations, that they include a statement that the individual has 20 days to appeal their decision to the BZA on a notice of violation. I think that's really important because if they don't appeal it and we have to enforce the code and take them to court, there's a legal doctrine that basically prohibits that individual from making any arguments as to why Jeff or Michelle are wrong. So any person aggrieved can appeal. Typically, an aggrieved party is an applicant, next door neighbor, typically not an HOA, typically not the Board of Trustees. So in order to be aggrieved, you have to have standing, and you have to be able to show what we call special harm that is not shared by the community as a whole. So that's why if you're a next door neighbor, contiguous or adjacent, you're going to be aggrieved, and you're going to have standing to appeal not only Jeff's decisions and Michelle's decisions, but the BZA's decisions as well. But once you get outside of that, it becomes a little more speculative. And, you know, I'm going to talk a little bit about that in a minute.
Pete, I got a question on that when you were talking about putting that in the violation notice.
Yeah.
We typically send at least 2 violation notices before we send it to the prosecutor's office.
Yep.
Do we have to have that? I mean,
so if your practice is you're going to always send 2, make sure it's in the second one.
Okay.
Right. Because that's, you know, if you always send 2, each time you make a determination, theoretically, the clock starts over.
Okay.
So make sure it's in the second one.
Thank you.
Yep.
And sorry, is it 20 days upon us mailing it, the mailing date, or the date of them receiving it allegedly?
So the court cases are all over the board on that. And what so do you send certified, that second one?
Usually.
Yes.
Yeah.
Yep.
So I typically run, so courts are going to kind of be liberal in their interpretation of when the 20 days start. So I typically run that 20 days from the date that they've signed that they've receipted it, or when they've signed the green card, or however you do it. That's when I run the 20 days. So I'm a little more liberal. And then there's no question, right? So I would run it from the date of receipt, not from the date of mailing. Conditional uses. I know you deal with them a lot. I love conditional uses because I think they provide a lot of flexibility for review, and then, you know, with placing conditions on, I think it's a great way to control. I'm sure you guys know this, but the only reason I bring it up is because I've seen people do it. You can't grant conditional uses for things that aren't permitted to grant them for. So your code provides a list of things you can grant conditional uses for. If it's not one of those things, you can't grant it. Variances. Again, you guys know this, use variance and an area variance. A use variance is the legal standard for a use variance is called the unnecessary hardship standard. And it didn't always used to be that way. There was just one standard until the Duncan v. Middlefield case. But a use variance, what I would tell you is that 99.9% of the time, you should not be granting them. It is an extremely high threshold to meet. And this is page 7, Jeff. There's really not it's not like an area variance where the Supreme Court basically just spelled it all out, put your test in the Duncan v. Middlefield factors. The courts have used kind of different standards over the years, and there's been 3 predominant kind of, if you parse it all down, there's been kind of 3 standards, and those are right in the middle of page 7, B1, 2, and 3. Unlike an area variance, if you don't meet 1, 2, or 3, you have to deny. So this isn't a balancing test. This is a, do I meet all 3 of these things? And if I do, then you can grant it. If I don't, then you have to deny it. And the one that always gets people is number 2, and what they call is the self-imposed hardship rule. And this is a famous Supreme Court case. And if you know anything about the Youngstown area, you know that the Bartolo family, who developed a lot of shopping malls, and obviously I think they owned I don't know if they still own the 49ers or not, but it's that family, basically wanted to put in a strip mall, and they had commercial property that was appropriately zoned, but it just wasn't big enough. And right next to it, residentially zoned property abutted it. They knew that there was no way that they were going to be able to get through the city to be able to rezone that residential area because people didn't want it. So they went to the BZA and had the BZA grant them a use variance to allow for a commercial use on the residential property. And the BZA granted it. Neighbors appealed it. The Supreme Court basically said, nice try. However, one of the factors is, did you create your own hardship? And if you did, then it should have been denied. And so did you have knowledge of the zoning restriction? And that standard is a known and actual knowledge, or you should have known what the code provided for. And if you did, if you're creating your own hardship, you have to deny. And that's what happened. And
that's almost every one of them should have known.
But that's for only use variance.
Right. But I mean, that issue is generally always there because they'll try to say they didn't know, but we have open records and you should have checked. And
correct. And that's why that's why I always, great point, Rick, because that's why I always tell BZAs is you can't prohibit people from applying for a use variance. That's their right. But if you really know what you're doing, if the BZA really knows what they're doing, it really should almost always be denied. This is a rare thing.
I agree.
So that's kind of the use variance, and what you guys typically deal with are the area variances, and that's the practical difficulty standard. That's the test. That's the legal test. And as you guys know, there's a famous Supreme Court case in '86 that basically said, well, because under the old law, what was happening is courts were basically saying townships had to use the unnecessary hardship test for a use variance. And when you think about it, if I want to, encroach my deck into the side yard setback like 2 feet, my new deck, boy, that's a really tough standard to meet, right? Like Rick said, I'm pretty much, I have to deny it if I know what I'm doing, because you knew that this was our setback. It's self-imposed hardship.
In regards to the unnecessary hardship, and there's a statement in there you have that one established, and I'm reading the last part of it, one standard established for use variance will be fatal.
Right.
Are you saying the word fatal because it sets precedence? Because as Rick said, invariably we're going to get the complaint, oh, it's a hardship, but define the hardship to who? Are they only going to get 300 customers a day where they expected 325 because the sign wasn't high enough or whatever?
Right.
I mean, I can understand it if it's based on topography. That's one thing. But I'm not getting enough traffic because the sign's not high enough. And that's going to be unnecessary hardship for us.
But remember, Jerry, that statement that you pulled from the unnecessary hardship is only for use variances.
Understand.
So what I would tell you is, I mean, like hide a sign, that's an area variance. But let's say someone comes in and what that statement will be fatal means is that if I as an applicant cannot show that I meet 1, 2, and 3, those 3 factors, that it's what it means fatal means that the BZA has to deny it under the law.
Okay.
That's what that means. So
Okay.
it's not a balancing test. I have to deny it. So in 84, the Supreme Court basically said, look, this is ridiculous. We need to, in area variances, they don't have as much of an impact as a use variance would on the surrounding territory. So they came up with the Duncan factors, and there are 7 of them, and it's a balancing test, right? So we have the property owner knowledge component of it that we kind of saw in the use variance, but it's not fatal in an area variance, right? It's just a factor that you have to consider in the overall package. And what the cases have held is that you, BZA, have to consider all 7 of those factors. And you have to balance all 7 of those factors. Now, you can do more, right? There can be other factors that you can consider in addition to those, but you have to, at a minimum, look at those 7. Let's say, not that Jeff would do this, but let's say Jeff accidentally allowed somebody to build a shed, and the shed encroached 3 feet into the side yard setback. They come in, they make an argument. I think a zoning inspector mistake can be an additional factor that you can consider. And I've had that happen. So again, I think the important thing that I want you guys to remember is it's a balancing test. I'm going to meet some as an applicant. I'm not going to meet other ones, and you have to balance those. So I want to just spend a minute going over those 7 factors. And when you think about number 1, will the property yield a reasonable return, or can there be beneficial use of the property without a variance? And the answer is typically, yeah, it can. Right? It still can be a church. It still can be a residence, right? Just because I can't extend my deck another foot. Typically, I'm still going to be able to use the property in which it was designed, what I'm intending it to be used for. Number 2, whether the variance is substantial. What the courts have held consistently is that anything over 25%
Wow.
is going to be considered substantial.
Good to know. Good to know.
Okay.
Yeah.
So if it's less than that, and that's it, and I think this is an easy one. So when you're thinking about it and when you're articulating your decision, if I'm coming in that deck, that side yard deck, and I'm only requesting a deviation of 10% from the setback requirement, well, the applicant has requested a 10% variance to the setback, and it is therefore not substantial. You've checked the box. I'm going to skip over 3, and I'm going to come back to it. 4, whether the variance would adversely affect the delivery of governmental services, water, sewer, garbage, fire. And we kind of have to rely upon others to provide. So there may be an occasion I've had sometimes where the fire department has an issue. They're gonna show up and testify or supply a letter. But a lot of times the answer is no. But there can be. It can affect. Let's take a sign. I mean, maybe it's a traffic, maybe it's a site issue, and we get the engineer or to say or our road department to say that they have issues with it. So that could be an issue. Whether number 6, whether the property owner purchase the property with knowledge of the zoning restriction? Again, we just went over it, but the answer is typically yes, because it's a known or should have known standard, right? Just because I didn't do my homework and get a hold of Jeff and Michelle ahead of time before deciding to build my shed in the setback, that's not on them. It's not on you as the BZA. That's on them. They should have known. It's simply a statement that, well, I really don't even know what zoning is. That's not good enough.
All right, let me,
Can I, I'm sorry, Jerry.
go ahead, Michelle.
I just wanted to preface that Jeff and I do meet with potential applicants quite frequently, or in hopes to avoid for them to come to BZA. I mean, that's typically the worst case. Sometimes there's applicants that are very adamant that they're going to come in and take the chance and go for it. But we really do try to work with them and show them the options prior to this. So I'm sure you all know that, but I just, I think if we didn't do that, if they didn't talk to us, you would be seeing a lot more.
Yeah.
Well, my comment or question is actually along those same lines, Michelle. In that if an applicant meets with you and okay, the thought process, yeah, it's a reasonable request. You have a 50-50 chance, and I'm just using that arbitrarily. So please don't take it that way, because I know that based on the experience working with y'all, both on the zoning side and the BZA side, you don't typically give a percentage, hey, this will pass, won't pass, whatever. But with that being said, I know before you came, Michelle and Jeff, it was done, and they would meet with the attorney or zoning, and yeah, it's passed. It'll get passed. You get a good chance of passing, et cetera. And it gets before the board, and it turns around that it's rejected. And then the applicant, you just wait. I'm going to get a hold of the media, and I'm going to do this, that, and the other. And that's actually happened.
I was there for one of those.
I'm sorry. It's actually happened where they threatened to say, hey, we're going to go to the media.
Was that the swimming pool?
That was a deck. Do you remember? It was a very massive deck, and he was going to call Channel 10 News or something. Right. And...
I remember the swimming pool.
Which one?
But
it does.
I mean, I think it's inevitable to not face upset applicants. I bet when they take a step back, they can't be too surprised of a denial, because we do warn them saying this is a substantial request. I cannot guarantee what the BZA will decide on, but you're requesting 3 times as much as we try to give them warnings.
Right. No.
We don't. I don't know if I'm answering your question, Jerry, but
Michelle, I am not pointing fingers at you or Jeff. So this is pre you or Jeff.
Yeah, that's a no, Jerry. So staff should not be giving recommendations to you guys. They should not be, they should not be saying, oh yeah, and I think you have a good shot, or it's 50-50, or.
Right. I'm not pointing fingers at Jeff or Michelle. So don't take it that way.
I am.
Okay.
And I think they do a fantastic job, because I was doing this before Michelle and Jeff. And it was, I can't even really describe it, but I mean, we've always should have had something like this going on that really explained a lot to us and everything. But no, Michelle and Jeff, I mean, you guys have done a great job as far as, when you get the applications and lining them up and explaining them. And I mean, every aspect of this is better.
I agree.
Since you guys came. Unfortunately, I spent a few years before you guys came. So
yeah,
I missed out.
Well, I'm here to take compliments all night, so thank you.
And you deserve them.
And we just keep trying to make it better for you guys.
Oh, yeah.
Yeah, well,
doing-
honestly, and I've said it a few times. It's unbelievable, really, from before and the after.
Well, I appreciate that, Rick. I really do. I think there's some things that Jeff and I still need to work on, especially as far as when you make a decision. I think we need to do better in the detail of, and I don't know, Pete, if you were going to discuss that a little more too.
Yeah.
So there's
Mhm.
definitely some improvement we have made, but I do believe that we have significantly improved prior to my time at the township, or since my time with the township, excuse me.
Yes.
So we're still a work in
Yes.
progress, but we're getting there.
Hey guys, it's my time to appreciate too.
Oh.
Even I was blessed to be a part, like before you guys came in, and it was so much amazing transformation. Like you and Jeff, you guys are doing amazing job. I have to tell you. I know, like even when you started, like I still felt like you guys are like really trying to fix the kind of like whatever was happened before you guys came in, right? You guys really fixed everything, and it's really amazing transformation.
Thank you.
Yeah, thank you guys. Thank you for doing all this. Thank you.
All right, not to break up the love fest, but we're going to continue on with the exciting Duncan factors. But so if you ask me, the ones I went through are kind of the easy ones. If you ask me where the battleground is at, I would look at number 3 and number 7. And I think that is truly the crux of what you're trying to get at. Will what I'm doing, will it substantially alter the character of the neighborhood, and whether or not the spirit and intent of the code would be observed. And that's where I think that's where it's difficult. And
Is
go
the
ahead.
25% rule again? Substantially?
I've not seen, good question. I've not seen anything that specifically ties those two together. Never really thought about it, but I think you could say that yes, but I think it's probably a little broader than that.
I do too. It's just we've had several cases come up, and they're normally in the backyard, pool, deck, patio, something. And most of the neighbors will never see it.
Yep.
But so to me, that one's almost a wash. That, if no one's seeing it, how does that affect the character? And
I agree.
Number 7, well, is it in the spirit? I don't think so, usually.
Yeah.
So
yeah.
What it comes down to is the variance substantial?
Well, it's going to come down to all 7 factors, remember?
Right, but you check mark all of them, and the only one that you're, really concerned about is that one. Does that tip the balance?
What, number 2?
Yeah, number 2.
Whether it's substantial. So what I would tell you is that I really do think, because I think we're getting to almost something else I want to bring up about precedent. And I hear this a lot in what I do. And what I always say is in my opinion, on the record, don't use the word precedent.
Yeah, but it's thrown in our face almost every time where Joe Blow business down the street has the same, they have more, or they have about the same as what we're asking, et cetera. So precedent is a major factor, especially with businesses along 23.
Yeah, but they're claiming that. They're saying that there's
Correct.
the precedent.
And I think you have
That's not us.
but they have to show you. And again, they may be looking at that particular, angle of it, and maybe that's the essential character component of it. But there still are other factors, and there may be a situation as to, well, maybe there was a reason why that variance was granted up the street. Maybe it's because, and this is this is in my mind. It has nothing to do with the application that's in front of you, but let's take the retention pond. I mean, is that a factor? Maybe that's the reason why you as a BZA decided to allow, them to, an applicant to encroach further into the setback. Whereas in this particular case, this individual doesn't have a retention pond, right?
Mhm.
And
Right.
they just want to be, their sign to be seen better, or it looks better, or whatever. So that's why I understand that. And again, I'm practical. I understand that in the back of your mind, Jerry, you're always going to have that precedent issue out there. And there's no way, because again, you're just like a judge. You're going to bring real world experience with you, when you're deciding these cases. But what I want you to focus on is that I'm considering each application on its own merits. And the burden of proof is upon the applicant to show me that this balancing test tips in their favor.
I fully agree with you, but some will say, well, it's a hardship if I don't have equal to Nationwide or Joe Blow Sign Company or whatever it may be.
Right. Yeah. Well, what I would say is that's a conclusory statement. You show me how. Tell me why. Provide evidence that it will be a detriment. Your statement means nothing.
Everything you talked about tonight, I faced with our property here at Ninja Express. Almost everything you've talked about, I faced with you guys, or I'm yet to face with you guys. So it's very interesting and it's right on point.
Yeah.
These are things I think about as a business owner in this area. So these are the correct issues, and they are exactly what I've dealt with. And yes, Michelle and Jeff are fantastic.
They are. And so what you're saying is we need to check 4 of these 7 boxes to not allow, to be weighted, right? So if we only do 3, then we should consider allowing it.
Yes, I mean, I think that's what you're weighing. But what I would tell you is that 3 and 7, in my opinion, are the crux of the issue. And I understand.
I think they're the vaguest. They're the vaguest.
They are. I mean, certainly, I know with it being substantial, that's obviously that's an important issue. But I think what you're really trying to figure out is kind of how all these other things influence 3 and 7.
Can I ask a question about what Rick just said? This is Dave Boyd.
Yep.
Okay. Did I hear correctly? It kind of sounds like Rick is advocating an equal weight to each of the 7 Duncan factors, but that's not necessarily so, is it? I mean, you can weight the totality of the 7 factors. It doesn't necessarily have to be like they meet 3. Maybe 2 is very important, but they meet all the other factors, and you can decide against that application.
David, that's a better way to put it.
Okay. I just want to make sure I'm getting it right. It doesn't have to be a math formula. You can decide that 1 is very important. The essential character of the community is violated, even though they meet every other factor, and deny based on that.
And there may be some times where nobody provides any testimony whatsoever on some of the factors. So
Mhm.
that's a better way to think about it, David. I agree. And that's why what I said earlier, 3 and 7, I think are really the heart of what a court's going to look at is, was your decision reasonable? And I think a court can say, man, yeah, what they're trying to do here is really going to change the essential character of the neighborhood. And it may be because some of these other factors come into play. You know, it is a 60% variance request. It is going to affect the delivery of government. I mean, so those are, I agree with you. Those are really subjective.
Yeah, it's more of a reasonable person test with ordinary sensibilities, right?
Right. But I think if you ask me what the 7 factors are really trying to get at, I would say 3 and 7 are really what they're trying to get at.
So are you saying that they're more heavily weighted?
I would, if I'm a BZA member, I'm looking at 3 particularly, in my opinion, and trying to make that determination is what I'm doing. Am I really gonna alter the character of the neighborhood?
Well,
now,
yeah. Now, see, I look at number 7, and it to me is vague and ambiguous.
It is.
You know, just because the spirit and intent behind the zoning requirements are meeting the zoning requirements.
Yeah.
So anything that is outside of the requirements
is not.
You know, just.
But why do we have the requirement? I guess would be the question.
That's because, you know, that's the essential character that we want in that area.
Yeah.
Which goes back to 3.
Right. And you're, Rick, I can't tell you that you're wrong.
Well, you can.
So, you know, I understand. And I've got, you could go to every single BZA that I represent, and everybody's going to have a difference of opinion, or they're going to bring their own experience and how they analyze those factors.
Sure.
And I certainly agree. 3 and 7 is fuzzy. And in my own personal opinion, is 3 is kind of the key for me. But there may be a situation where a variance is so substantial that it is going to affect the delivery of governmental services or create a traffic hazard, while it may not necessarily alter the central character of the neighborhood. And there may be those other factors that I have to weigh heavy, you know, as opposed to that one. So what I want you guys to do is to go through and really think about those 7 things and everything. I mean, this is great conversation that we're having, because I think you guys are really kind of fit, you know, in your own minds, figuring out what those things mean. And then apply them to the facts, of that application.
Well, I know number 4, we're always looking at accessibility by the fire department.
Yep. That's perfect.
And sometimes even ask them to have them look at that and make sure that, you know, access and everything will be possible for the delivery of their service.
Yeah. Yep. So those are things that you should be considering every application. Now, while we're here, I want to bring this up again. I'm very practical, and I think if I'm you guys, I would want to get in the habit, even in the most mundane area variance cases, of running down through those factors just real quick, and then making a motion, you know, based upon the above factors, I move to approve, you know, the application.
Okay.
I would start getting in the habit of that, and I just think it's a good habit. It doesn't take that long. And I don't know if Jeff sent you kind of
I can tell you yes before you even say what it is.
What we've done in a couple other places. Just real quick, it lists the factors out, and it's just kind of like a scripted statement. And I would just get in the habit of doing that. And then particularly, let's say, I don't have a bunch of attorneys in the room, and it's just, and I'm going to deny something. I would definitely give the reasons why I'm denying. So I would just never make a motion to deny. It's got to be, these are the factors that we need to consider. Here is why the applicant has failed to meet his burden. And based upon those factors, I make a motion to deny the application. So
as a board, that's something that we are very careful about, whether it's approval or not of just that. We don't want to get burned.
Yeah, and actually, I would like to see maybe Jeff put those 7 items, in our paperwork on each one, so that we could kind of go through it and, maybe make some notes that, yeah, well, I don't like this one, or, and kind of use that all the time.
They are in our staff reports at the end. That's kind of the motion that's drafted at the end of the staff report. It's kind of based on what's in the zoning resolution, but and he did provide some sample motions here that he did send to us that we'll be looking at trying to incorporate into our staff reports, and we'll have them.
I even played Kelvin, and I found a spelling error in there.
Hey, I didn't write those. Jen did.
I didn't figure you did.
So,
somebody else.
You know what's great about it is Jen is a Notre Dame graduate, and she was an English major. So I am going to rib her tomorrow when I see her.
Oh, you caused trouble now, Rick.
Wouldn't have been.
I have a question about the factors.
Sure.
We have them in front of us, and I go through and I say yes, no, no, yes, whatever. Is that list that I've now checked part of some permanent record?
Yes.
So I have to hand that to Jeff or Michelle?
No, I'm sorry. Actual physical
just your
paper,
decision.
So it depends. If you just want to be able to verbalize it, and let's say it's Kelvin, it's your personal notes, the answer is going to be no.
Okay.
But some BZAs will actually, particularly when they're together, have a complete form, and they'll handwrite in there, and then they'll use that as the decision. The answer would be yes. That is part of the official record.
Okay.
But I was thinking the same thing, Kelvin.
Yeah.
Is going through these each time and writing my own note, whether I think it's substantial or whatever, and making my own note on all those, and then coming to my conclusion if it's a yes or a no. And it's always going to be most important when it's a no.
So
but yeah,
the other thing I want to mention is typically, well, not typically, but sometimes the BZA will place conditions upon a variance or conditional use, and that's perfectly permissible. What I would tell you with conditions, I've been in a couple cases on just conditions where we've approved applications and the applicant has appealed because they didn't like the conditions. It obviously has to relate to what you're considering. And there has to be some basis for why you're placing the condition on it. And I want to bring this up to you guys, and this is by no means a knock. This is for my own personal edification, because I don't have an engineering background or something like that, but I'm really fascinated as to your lighting condition. And can you explain to me, just so I know, why you put that limitation on, and what's that based on?
Ohio State Planetarium on the south side of Delaware.
Okay.
Blue light, 5,000, 4,000 Kelvin really throws the planetarium off kilter.
Okay.
Also, when it's reflected out to cars and stuff, that's a very glaring light, and it can cause people to not control their vehicles.
Look, think of it this way: when European cars, about 5-6 years ago, I'm sure if you were driving at night and all of a sudden you see them bright blue lights.
Yep.
You turn your head, oh my God, that glare is killing me. That's the reason.
Okay. Let me ask you this: how did this get? How did it come up? And again, I'm just wanting to learn. How did it? So I'm assuming at some point in time, the BZA never required this, and then there was
It's
a case.
still not a requirement. It's a condition we put in.
I'll be the frank one. It was our previous legal counsel that
I was just gonna
suggested
say that.
doing that.
Yeah.
Okay.
He was the one that always told us that that's the one thing that we wanted to adhere to.
No, and that's why I'm just asking, because I've never seen that before, and I just wanted to know the genesis behind it.
And we don't, and it's not in our code. So if a wall sign comes in and meets the standards, I can't enforce the Kelvin temperature of what they do on the monument sign. So it does change, and you can have a brighter sign on the building than you can on a monument sign.
Yeah. No, again, and I don't want anybody to think that I'd never seen that, and hell, I didn't even know what is it?
Kelvin temperature.
Yeah,
Kelvin
you know, and I was just like, wow, that's interesting.
Think of the blue lights in a car, how obnoxious safety issues abound with it. So it's a combination.
So what I would tell you is, again, going back to using the word precedent and so, you know, saying we always do something can sometimes be dangerous.
Well, we when we do a conditional, we make the statement in regards to the Kelvin as a combination of safety factor along with the planetarium. And that's another reason why they don't have street lights in Lewis Center.
Yeah.
Bright lights. Safety. You think it's just the opposite, but that's the way it is.
But our code says it's okay.
Our code doesn't have anything on it.
Right,
yes.
Right. There's nothing there.
So I'm just playing devil's advocate here,
No,
guys.
and I think.
Should
Pete, tell me if I'm
we
wrong.
go away from that?
Well,
Should we just mention it and say we would appreciate you keeping it at 3,000 Kelvin and just hope they abide?
And that would drive Jeff nuts.
I almost think we should just amend our zoning resolution and include that as a standard if we're so adamant about it. But
Yeah.
Well, that and the number of lumens. So on those. signs.
Yeah.
So no, again, I don't want to change your practice. I just think that if Michelle kind of got to where I was headed, that if the township as a policy decides that, hey, we really think this is a good idea, then maybe we should be amending our code.
Well, part of this
Putting it
goes 2 or 3 years ago, there was an applicant that came forward that wanted to put up digital signage. It was just going to be plain lettering. Code had that you can't have digital signage. In this day and age, digital signage is the future.
I think we will be, I mean, I know I've been saying this for a long time, but we are going to be revisiting our signage code, hopefully this year. So, you know,
I thought the big thing was moving, digital moving
well,
and rotating and
right. I
color
mean,
changing. And
that could be anything. So a fuel price, you know, it's just that
yeah,
those numbers do change, you know, so, but
well, I think it was the, you know, the ones that had
Flipping.
constantly.
Yeah,
yeah.
Yeah. And then I found out the school over here has it. So
Several.
zoning has allowed it already.
That wasn't zoning. That was through the board of trustees.
Yeah.
yeah.
Oh, board of trustees. Well,
Yep,
so
that
I
was-
won't say precedent.
That was years ago.
Thanks, Rick.
Yeah, there you go.
I'm gonna sleep good tonight, Rick.
I do have,
The,
so Pete, how do you, oh, go ahead, Jerry.
the station that told us in the drawings that it was going to be a chalkboard, only to find out it was going to be an 80-inch video monitor
Yeah.
in front of their store.
Yeah.
They were pitching a fit that it was their mode of advertising.
Yeah.
It was right there on 23. It'd be very unsafe to have moving billboard graphics.
Right. Right.
Yeah. I think a lot of the moving stuff is eye catching. And as soon as it catches your eye and you turn your head, you know,
Are we
that's when
kidding?
people.
Are we kidding? What about cell phones?
Oh,
Say
that's
again,
true too.
Don?
But
That's my,
I didn't
agree.
hear that.
I think they should have put something in the phones to shut them down once that accelerometer knows you're moving.
It's bad for business.
Yeah. Keep in mind, there's no texting laws.
Yeah.
Yeah.
Well, if we could stay back on track, Pete, I do have a question.
Yeah.
As far as conditions go,
Mhm.
how do we feel about doing conditions on a conditional use? So if they satisfy all these criteria, is that a concern if we add conditions to that?
I think that legally, if there's a reason for it, I don't have a legal reason to have concern.
Okay.
Because there may be a situation that the code doesn't cover. And that's the whole purpose of a conditional use, is it's a use that may be permitted, but we're not going to permit it until we have an opportunity to review it because it may have special impact. So we just need that additional review. And it's not, in my opinion, uncommon to put conditions on a conditional use. But again, I think the key is making sure that it's related and that it's necessary, and that it's justified.
I can give you a perfect example of one in Westerville. They did not want wrecked cars on our auto body lot. And obviously we have wrecked cars on an auto body lot. So they asked us to point the damaged end of the vehicle away from the road.
Interesting.
That was fair.
Yeah.
Mm-hmm. Mm-hmm. Well, we had one where the guy wanted to open up a mechanic's garage over there in that little Lewis Center old neighborhood, you know, and we had issues with contaminants as far as, you know,
Right.
engine oil and gasoline and antifreeze, and the church was, you know, a few houses away, and they're like on a storm drain system. Yeah, that one was.
No, and Rick, you bring up good points, and that's certainly if the code doesn't address it or doesn't establish that minimum, and you see a potential issue, then absolutely, I think you can place a condition, but just as long as, you know, it's justified and you know, there's some basis for why you're doing it.
Okay, I have, based on your statement you just made, Pete, I have a question for you, and I've asked this to past council. If we know that it is an issue of contaminants, for an automotive place as an example. We're not supposed to drive by a place before we have it come before us. And I've been told that's because we're quasi-judicial, not a legislative, whereas regular zoning is legislative.
Right.
But that also puts us in a quandary that we don't have the ability to see on a day-to-day basis how it would be impacted by approving or not approving
Right.
a particular thing that's brought before us.
So let's put it this way. So the applicant is required to show you that he's entitled to a conditional use. The burden of proof is upon him. And if you believe that on the basis of his type of use that there could be a contaminant issue, he needs to show you that there's not. So the burden of proof is upon him to show you that there isn't.
Okay, with that being said, I'm sure that at one point or time or another, that there is an applicant that may not tell all the facts and may lie like hell, excuse my language, about X, Y, or Z. You know,
Right.
They're going to open up a health facility and come to find out it's a massage parlor. You know, and I'm not saying that against legitimate businesses, but non-professional type, I guess is a way for me to put it. So with our inability to go by to take a look at the surrounding areas, it puts us in a quandary of the 7 factors that we're supposed to be used to consider.
Yeah. So how about this then? So again, knowing that you can require them to submit the information and not just taking their word for it, Jerry, but let's say they need some type of environmental specialist. Have you had anybody out and can you provide a report? The other thing that I've done it a handful of times is you have the ability to judicially view the property
As a group.
Right. Yep. I've done that before. Those are fun. So you have that ability, and that's certainly acceptable. That's a rare circumstance, but you have that ability. And what I would tell you is, look, I'm practical. Members drive by drive through the township. Heck, you live there, and you may drive by a place. I get that. What you don't want to do is make a statement that, hey, I was out there, on the property or in front of the driveway looking at your place, and this is a lie.
Right.
There are other ways to do that, but
so if the I'm sorry, if this is because I didn't know this, if the board goes collectively to a site, how is that handled as far as like a public meeting? Am I like video?
So typically when we want to view the site, we will continue the hearing to a time, date, place certain, and then we will actually open up the hearing and say we're going to reconvene at the site. Everybody's there?
Yep. Yeah, and then is that just I do public notice and record it and?
Absolutely.
So Jeff's going to have to get his bearded wonder camera out there to FaceTime it.
Yeah.
They're going to think we're doing an episode of Duck Dynasty.
So you can do that in those rare circumstances. So conducting the hearing, I have some information there. Again, I think you need to be practical. I have on page 10 a couple things I want to briefly point out. You guys swear people in. That's perfect. limiting testimony, don't do. Don't tell somebody that they can't testify.
Right.
You have to theoretically allow for cross-examination. So typically you only see that when attorneys are involved, but there could be a situation. A property owner has the right to represent themselves. Say I'm an applicant and I file for a variance, and the next door neighbor wants to cross-examine the applicant. They have a right to do that. Now, most people don't know that, so it's not going to happen. But I was in a appeal, and again, typically it's just attorneys, but I was in an appeal not too long ago. The neighbor had an attorney, the property owner had an attorney, the zoning inspector had an attorney, and the BZA had their own attorney.
Wow.
And so when the zoning inspector got called, the neighbor's attorney cross-examined her, the property owner cross-examined her, and then the BZA's attorney also asked her questions. So you have to allow for cross-examination. You don't have to say, do you want to do it? But if an attorney requested, or a applicant or adjacent property owner says they want to, you have to permit it.
Well, I think what we do is if the applicant gets up and states their case, we will ask, is there anybody else that would like to talk in regards to this particular matter? And people do go back and forth. And there has been a couple of testy scenarios where, Susie says one thing and Johnny says another. But that
gas
does happen.
station deal.
Right.
The gas station deal was kind of involved. So if we have somebody that wants to cross-examine them, should we have that person that is testifying at the time come to the other side of the podium and face them in the chairs rather than us?
No, I would kind of have the person who's asking the question, conducting the cross-examination, kind of stand
behind
next to them. I would bring them up, right? Because,
okay, bring them up front.
Bring them up front.
We have to make sure they're mic'd or some way to
correct
be heard.
Right.
Correct.
Right.
But here's what I would say about cross-examination. The only people that have the ability to cross-examine would be somebody that can appeal your decision. So if it's a contiguous or adjacent property owner, I would let them cross-examine. But if it's somebody that's a mile away that's upset about a gas station going in, they don't have the right to cross-examine. So if they start asking questions to the applicant, I don't think it's okay for just average resident to be questioning the applicant. What I would do is ask them where they are, where they live, and try to determine whether or not they have standing to appeal your decision. And if they are contiguous or adjacent, I would let them cross-examine. If they are outside of that radius or outside of I think you guys put a 200-foot notification in. If they're outside of that, I wouldn't let them engage in this back and forth. It's not appropriate, and we need to control the hearing. So it can get really tricky, I guess is what I'm trying to say. Because theoretically, when I tell you, let everybody testify and don't put time limits on it, theoretically, you're only truly concerned with those people who have the ability to appeal your decision. And here's why. If you don't allow people who have the ability to appeal your decision to testify, or place a 2-minute limit on it, or don't allow them to cross-examine, or don't swear them in, and they appeal your decision and they say, Judge, they didn't let me cross-examine, or they only gave me 3 minutes. The judge then is required by law to open up the record and conduct another hearing. So what you're trying to do as a BZA is you're trying to try to tie the Court of Common Pleas hands and confine his review to the record that you've created. And if you do all the things appropriately procedurally, what a judge has to do is look at that record and say, was their decision reasonable and did they justify it? And if they did, I can't overturn it. But if you don't do those things in procedurally, then he has to open up the record, and the applicant really, or the property owner, gets another bite at the apple.
Okay, I'd like to ask a question in regards to the items on the top of page 12. You got, or page 10, excuse me. You got reporting, podium, court reporter.
Yeah.
My question is twofold. Since we do FaceTime live, that is considered a legal document per se.
The public record, yeah.
Right. So do we need a court reporter as well?
No. So my advice on court reporters is only if you know it's going to be one of those hearings. If you know going in that your decision is going to be appealed either way, because you have that many people that are upset, get a court reporter in, even if you're doing Facebook Live. Okay.
Okay. And the other point is, with us having to do everything remote up until coming up here in the next month or two, podium. So we're doing everything from home office, Zoom, whatever. No need for a podium.
No.
And the last part of that, you have number 3 there, multiple meetings. Are you referring to multiple meetings for the same case to where?
Yes.
Okay.
Yeah. So you're not under any requirement to hold this thing in one night and finish it all up.
Right.
So I also want to make sure we understand that there's a difference between a continuance and a tabling. A continuance is I'm continuing it to a time, date, place certain. I know when that application is going to be back in front of me. A tabling is that I don't know when it's going to be brought back up. So an applicant may say, I'm probably going to need 3 months before I get that information back to you guys. So I'm going to request that we table it. Now, the downside of tabling it is that Jeff and Michelle are going to have to renotice everything again.
Right.
With the continuance, we don't have to do that.
Right.
So I just want to make sure you understand the difference between the two. And then again, perfectly acceptable to continue and have multiple meetings. And you could, and once you're done, let's say you're in one of those situations where, you need to get me or the prosecutor involved, and we get everything we need. We meet privately, and we say, okay, Pete, or Chris or Mark at the prosecutor's office, and they say, hey, why don't you put something together for us? Put a written decision together. We will make sure we really have this thing rock solid. You can come out, close the hearing down, and you can render a decision later. There's actually, your code says 30 days. That's not the law. It's the law because you say it is now. But you don't have to, you just have to decide a case within a reasonable period of time. So I just want to, that's why I have multiple meetings up there, just to kind of hit on those couple things.
Okay. The other question is individual versus mass swearing. We're very careful that people, and I don't remember of us ever missing one, but if somebody does start to talk or want to get up and ask a question, we always ask them to state their name, address, etc.
And if they were sworn in.
Yeah.
Perfect. Yep. And that's why we have that there as well. So if you do a mass swearing in, And then you just say you were sworn in correct. You may proceed. Yep.
All right.
That's perfectly fine. And again, the reason why we do that is because there's a list of things that the judge can open up the record for. And one of those is that an individual's testimony was not provided under oath. So that's why we want people to do it under oath, so we can say, Judge, look, we've met this requirement. You can't open up our record.
And based on our history, if Rick misses it, I pick it up, or Mrs. Dart picks it up, or Calvin picks it up, one of us is very conscious of that.
Yep. No, and I didn't.
And we've had people that didn't swear in the beginning, and then once the thing got a little heated or whatever, then they wanted to testify.
Yeah.
I think Mr. Boyd has a question. I think, or at least he's raised his hand.
Yeah, I did throw my hand up out there. I just didn't want to interrupt the current discussion on that part. But just going back to the cross-examining. So let's say we determine they're likely a qualified appellant, or could be a potential appellant.
Yep.
And they want to do cross on the applicant, and the applicant doesn't respond or refuses to respond to the cross questions. What position does that put us in? What's our responsibility with regard to that?
So what I would do in that particular situation is I would, hopefully the chair would basically say, answer the question. And ultimately, you don't have the ability to hold them in contempt, right? As much as we'd like to sometimes.
We could state that they have refused to answer the question, though.
Correct.
On the record, right?
Yep, exactly right, Rick. So you make a statement then that the applicant refused to answer the question. And I think ultimately what that goes to is the credibility of that witness or the applicant.
That makes sense. Thank you very much. Also wondering, when we swear people in, if we have someone who appears to be so far removed from the process, like a non-citizen of Orange Township, commenting on an issue that's occurring within the township, and forgive me if everybody already knows the answer to this. What's our responsibility there? Do we still allow all testimony?
Yeah, so if you're 100% sure and they're not a resident of the township and they really have nothing at stake, I think you don't have to permit them to testify. And my former partner, Don, was the chairman of the Bexley BZA, and God help them on that BZA, but they have like 20 variances every meeting, and he would actually on every single case limit who could testify to those who had standing, just to be able to get through things. So you could do it. So what I would tell you is that townships are an awesome form of government, and if they're a township resident, I would let them testify. If they're a non-resident and you have a lot of people that want to, I would not. And then if you know that they live on the other side of town, they're still a township resident, they're other side of town, and they don't have standing, I probably would let them give their 2 cents. And if they continue to drag on, I'd probably shut them down at that point.
Good. Thank you.
Yep.
I'm also totally behind the codifying of the signage, Kelvin. I'll dig up the model if needed. Thanks.
So I have sample hearing format in there. Everybody does it different. But the one thing I want to know at the bottom of 10 is deliberate renders a decision. So one of those things, remember where I told you a judge could open up the record? The statute actually states that did the BZA issue findings of facts and conclusions of law? So if you don't issue those, a judge has the ability to open up the record. Now, what we've seen in cases is that if you don't use the magic words, findings of facts and conclusions of law, that courts will kind of extrapolate from the record that that's what you've done. So again, if we get into that really nasty hearing, we're going to have you issue findings of facts and conclusions of law. And we'll check that box. Appropriate evidence, real quick, rules of the civil rules of procedure that you would see down in the Court of Common Pleas don't apply. Right. So if someone makes an argument, hey, you know, under the rules of procedure, you know, that doesn't apply. Your rules of procedure are contained on page 11, 25, number 3 on page 11, and I think it runs on the page, the top of page 12. That's what you have to concern yourself with. Those are the things that I just told you that a judge can open up the record. Outside of that, you know, what you do is, you know, you're not going to get into the hearsay rule or anything like that. But I want you to really think about the type of evidence that you typically hear, the type of testimony that you really typically hear. Most of the time, it's speculation. You know, hey, you know, you can't put this garage repair next to me because it's going to decrease my property value. Is that fact?
No.
Or is that speculation? That's opinion, right?
It's opinion.
Or it's going to be too noisy, or it's going to increase traffic. The real good people, the real ones that know what they're doing, are going to have some type of report provided by some sort of expert. They're going to hire an appraiser. They are going to do a traffic study. They are going to provide you some statistical evidence that what they're saying is true. So the example that I want to give is Jerome Township, up off 33 in between Marysville and Dublin. They have, as a conditional use, they have they allow for transportation facilities, distribution centers. So FedEx came in and wanted to put in a distribution facility up there. And so the residents said traffic, they said noise, they said property values, light pollution. FedEx, who, as you can imagine, knows what they're doing, walked in with expert after expert who provided reports on traffic, impact. No, they actually had a noise and light expert from MIT provide an analysis that it wouldn't impact.
Wow.
So, you know, again, that's an extreme case, but I think it serves a purpose for what we're talking about tonight. You know, you can have residents say that it's going to do those things, but there needs to really be, when it gets down to it, and our decision is going to be appealed, either way, there really needs to be some type of evidence, substantive evidence to support what they're saying. I had a lady on a storage unit case where she actually did a good job. She had a real estate agent and she hired an appraiser who both came in. She was just an average resident who both came in and testified on her behalf. It shows that if this thing goes in, it's going to decrease her property values. And the board relied heavily on that and denied the request for conditional use. So it's that type of thing that carries weight.
It's fact versus hearsay.
Or opinion, right? You know, speculation. Right. So, poorly worded zoning resolutions. So this is what I want to tell you about that. If a code is ambiguous, the tie goes to the property owner, to the applicant, for free use of the property.
Mm-hmm.
That's what a court will decide. Res judicata is just a fancy legal word that basically says that I can't keep filing the same application over and over in front of you. So if I keep filing the same variance request, you don't have to hear it. only if there's a substantial change in circumstance or in my application do you have to rehear it. And typically what we've seen is courts follow along in the Duncan factor, they kind of follow along that 20 to 25% threshold. So let's say I want to build an accessory structure and you deny me, they're done. They can't come back and file the same application again unless, let's say, they reduce the size of that structure by 20%. That's a substantial change in circumstance, and you can hear it now. Failure to appeal. So you render a decision. Typically, it happens in a denial. They don't appeal it to the Court of Common Pleas. They're done. They can't. They're going to have to comply with the code. It's a lot of times what you'll see is I call this the ask for forgiveness situation. So if I've already built it and now I'm asking for forgiveness and the BZA denies it and I don't appeal it to the Court of Common Pleas, they're done. Jeff and Michelle have to enforce the code. Reconsideration. I don't know if you guys knew this or not. You actually have the ability to reconsider your own decision until your decision is appealed or the 30-day time limit to appeal your decision expires.
Okay.
You won't find that in the statute. That's born out of cases. And I don't see it very often. I've probably had it 2 times in my 20 years.
Okay, I have a question in that regard, and I'm not going to name the entity, but I felt I was bamboozled by an applicant. They made a great case, but after the fact, when I saw their building, I thought to myself, my God, I can't believe I let that get approved, or I voted for that. And I actually apologized to the board for it. Again, I'm not going to name what the business was or whatever.
I can.
No. Anyhow, if I don't agree with something after the fact, when I see the building or whatever, I have 30 days to where I can request it.
So what I would tell you is that your reconsideration should be based upon some form of new evidence. And typically where I've seen it in a couple cases that I've had is where the applicant provides additional evidence or has something that they didn't provide before. And it usually comes in a letter format and says, this is additional evidence and I want the board to reconsider their decision. So I think if you have new evidence, I think you can reconsider your decision. I don't think because you have buyer's remorse, if you will, that's a legitimate reason to reconsider.
I wouldn't call it buyer's remorse, but the way the picture was painted and the drawings were provided, that we need this because we're going to be so far away from this particular roadway. And that's why we need this color and this size, font size, if you want to call it such, or the size of the letters. And come to find out, again, this goes back to a scenario of us not being able to drive by.
Right.
I felt like a jerk.
I felt more sad about the 2 churches that wanted to put up digital signs, and we kind of shot them down. And then I find out, oh, there's already a couple digital signs at the schools and some other businesses.
Right.
I kind of thought we should have gone back and said, hey, you know what? We've looked at that again. And, you know, even if there wasn't a time limit on it, I mean, you know, because what they were doing wasn't egregious in size or anything like that. It was pretty much the digital signs.
No,
Yeah.
Rick, and agree with what you're saying.
Yeah, Jerry, I would just tell you in that particular fact pattern, I would probably be really hesitant to reopen it unless I had something, new evidence that wasn't brought before me as part of the hearing.
Right. Well,
So,
and like I said, I later realized that we did have, the same type of signs with moving LEDs and
right.
all that at a school.
Yeah,
Well,
but
And
so understand schools are different. So governmental entities, here's the rule with governmental entities. They are subject to zoning, but they only have to make a good faith attempt to comply with it.
they didn't even come through zoning. They went straight to the trustees.
Exactly. So what the case law basically says on that, Jerry, is that the good faith attempt doesn't mean that they have to request variances or conditional uses. So blame the courts. So
this is another place where codifying it would help us though, right? Because then we could say they're either conforming to what's in the code or they're not.
Right.
Same with the font size thing. If we could say, is this visible at a distance of 500 feet? You know, when can you first read the sign type of thing? And if we had that in a standard, then somebody can't bamboozle you because it's
right.
a fact. So.
And typically they tend to want to be a good neighbor and work with you. But I had a nasty case in Pickerington with a bus transportation facility, and they basically just gave the township the middle finger and did what they wanted to. So
for this,
we call them Panera Bread.
Yeah. Unfortunately, the situation, it was against code to have a digital moving signage.
Right.
So that's what hurt them.
Yeah, and I think they, and they probably win it if they go to court. If you were to take them to court, they'd probably win because they're a governmental entity. But
but my thing is, I don't buy into the government can do whatever they want, and then you hold everybody else to a stricter standard. If it's already been done, then I think we should let everybody do it.
Rick, that's above my pay
check
grade.
your code.
Hey, you're the attorney now.
Okay, moving on.
Yeah, real quick, guys. And I think what I would like to do ultimately is I'll talk to Michelle about this, is maybe just having like an ethics training with zoning commission and the BZA, where we can just simply talk ethics. But what I want to just tell you briefly is that here's the upshot. You can't take bribes, right? So that's easy. The hard part is that what the ethics laws say is that you cannot use your position to secure a thing of value that would have a substantial and improper influence upon you as a public official. So what that means is a thing of value is to you, your family, or your business associates. And a thing of value can be a benefit or a detriment. Okay, so you is easy, right? You as an individual. Family means your parents, your kids or stepkids, or adopted kids, your siblings, or anybody who resides in your residence. All right. Your third cousin Willie, he's okay, right? You can hear his application.
I don't have a third cousin Willie. Elizabeth, fourth removed.
So the question that typically is presented for BZA members is, when am I prohibited from hearing an application? When would something have a benefit or a detriment to property that I own or one of my family members owns? And it's going to be if a property is contiguous, adjacent, and I love attorneys, or nearby. Okay.
Yeah.
But they did give a little guidance. Nearby, the only ethics opinion, written formal opinion, is 150 feet. So if I'm contiguous or adjacent to a property that an application to my property, I need to recuse myself. And recusal means that I can't talk to any other board members. I need to step away. Okay.
Okay, so if it's a neighbor in the neighborhood, but they're, several houses down the street and not right next to you, then you
Right.
can hear it.
Correct. So what I would tell you is that you guys, I kind of use, assuming you have a distance requirement in your code, which you guys do. So the law basically says contiguous and adjacent property owners should receive notification. But then a lot of times what townships will do is they'll put a distance requirement in addition to that. And you guys put a 200-foot requirement that people are going to be notified 200 feet. If you receive a notice from the township that a hearing is going to happen, I would recuse myself. Because the purpose of that notice is we're basically telling you, you have the potential to have special harm by this application or to be impacted by this application.
A good way to look at it.
Yep. And then you just because you're a member doesn't mean you give up rights. You can certainly request variances. If you want to show up to a rezoning and say, as a resident, say I'm opposed to this rezoning, you have that ability. Identify yourself as Pete Griggs, average Orange Township resident, and not Pete Griggs, Orange Township BZA member. That's where you get in trouble, is when you identify yourself as a BZA member. Simply, you're an Orange Township resident. I'm a concerned resident. But you have that ability to show up. Now, you can figure out the political mess and whether the trustees will be mad at you on your own. But certainly nothing wrong with you showing up as a resident on a zoning matter. I have trustees' attendance at BZA hearings. 99.9% of the time, the township does not have standing to appeal your decision unless it deals with township property or impacts township property. They don't have standing. So what I would tell the trustees is stay away. You appointed these guys to do a job. Let them do their job.
So, but you're also saying, and this goes both ways, that if we go to a trustees meeting, just because we're interested in to see if the trustees are going to approve whatever that Twinkie factory is, that we shouldn't do it.
Well, no. So what I would tell you is that if on the Twinkie factory, that you can show up and say, I'm Pete Griggs, Orange Township resident. I'm opposed to this for ABC. Me personally, if I was on, and this is my own personal opinion, I wouldn't. But that's just me. But that's just because, I got my start and, I got my start and worked in the Senate for a long time. And that's just, my political brain working. But there is nothing legally wrong with you doing that from an ethics standpoint, as long as you're average resident and not identifying yourself as a BZA member.
Okay.
So that's really what I wanted to just point out is that if I get a notice from the township on an application that's before the board, recuse yourself. So what I would do is I would rearrange your agenda and put that last and have everything heard. And when you get to that, say, Mr. Chairman, I have a conflict on this application. Therefore, I'm going to recuse myself. Everybody have a good night. I'm going to go down and get some wings and beer.
I wouldn't want that on the record.
Especially since Calvin was supposed to bring us wings and beer for the next meeting that we're going to have live, or was it Jeff that's going to provide?
I think it was Jeff. That's my recollection.
Oh, I heard it was Pete was going to have a big dinner somewhere with both of us. BZA and zoning.
So guys, that's I know we went longer than the zoning commission. But
that's because we're smarter.
Yeah, I know.
Quasi.
You're quasi. Yep. And
we're
so
Quasimodo.
That's kind of the spiel. And down the line we can do more education and make it a little more pointed. But I kind of wanted to throw a lot at you tonight. Get that
a lot of good information.
Going. So, does anybody have any questions?
Pete, I have a couple things. I know sometimes we get, the board kind of gets caught in the weeds sometimes, gets off topic sometimes, and starts discussing things that isn't really in the application or about how something's designed. What role on my part can I step in? I know typically the chairman usually steps in, but I don't want to overstep my bounds or, what I'm allowed to do to cause issues if we get appealed or anything like that.
Yeah, boy, Jeff, that's a really tough question. And I would, if you're basically saying, look, I'm not sure that's part of the application or we need to be considering that, I guess I don't know your relationship with the BZA well enough. From a legal perspective, I don't think it's going to cause me heartburn if you do that and just try to, in a nice way, bring them back around. But that's really incumbent upon them to know their role and their duty. But, I don't think it's going to kill us one way or another if it gets appealed.
Yeah. And then if the board then tries to negotiate with the applicant, is that going to affect how?
That's another tough one because, typically I would tell you it's almost like playing poker. And what I would tell you is that it's their application and the burden of proof is upon them to prove that they're entitled to it. And the ones that really know what they're doing are going to get a read of the board and know when they should be trying to figure it out and it come from them as opposed to coming from the board. But I think big picture, no, I don't like negotiations. Again, I think if it's applicant driven, that's okay. But I don't want, again, any preconceived standards coming from the board to the applicant, if that makes sense.
We stress that we're not, or we try to stress that we're not there to negotiate, nor is it our position to negotiate. We do state that we will try to give some guidelines to help the applicant, but that we're not there to negotiate.
Yeah, no, and I think that's the right way to do it. And again, what I would tell you is got to be applicant driven. If it's applicant driven and they're the ones if it comes from the applicant and they say, look, we'll reduce this by X, I don't necessarily want you to say, yeah, okay. It's incumbent upon them to basically say, all right, I'm going to reduce my application by X. And then you guys can make a decision. And if it's, look, I still, you're at 50% variance request and you're only reducing it by 30, it's still substantial in my opinion. And if they basically say, okay, we're going to amend our application, reduce it another 10% to bring it to 18%. Okay, well, now it's not substantial. So again, applicant driven. And like I said, that's difficult because a lot of times we're kind of playing poker, and those applicants who know and do a good job can read the board and move in that direction. But again, no preconceived notions or standards, and not that you guys have done this, but it's always got to be X, right? You have an application and we have this precedent and it's always X. So unless you're going to agree to X, then we're going to deny your application. That can get you in trouble if that decision were appealed.
That's all that I have. I don't know if anybody else has anything, if Michelle has anything.
I don't have any questions, Pete. This is Aaron. I don't have any questions, but the information in the packet that Jeff sent us is fantastic information, and the information you put out tonight is quite helpful. So I appreciate that. Thank you for your time.
Yep.
I agree. Yeah, it's long overdue, and getting us on track.
If you guys have questions, get a hold of Jeff and Michelle, and I mean, they know where to find me.
Sounds good.
I guess I do actually have one more question for you.
Yeah.
On the sample decisions that you sent us for, if they do the denial, would we just fill that in at the hearing and to write that in, or?
Yeah. So again,
do that?
Understanding the context and how you're operating, assuming it's, you don't have a bunch of attorneys in the room, then yeah, I think you can.
Does it matter who does that?
Nope.
Typically when we do stuff like that, the staff usually does it, fills that in, and then.
Yeah, I mean,
or do you want the board?
So it should be articulated by one of the board members.
Okay.
Yep, because remember, Jeff, I mean, you could be considered, and typically are, an adverse party.
Right. And typically we're kind of like the secretary at the meeting.
Yeah.
So that's where we kind of have it, but then we would make them read it. We would just write down what conditions they put on or what they stated, and then make them read it, or we can make the chairman do it. So
it can be any board member.
Okay.
A lot of places will just take turns really on making motions. I mean, it can, whatever the board wants to do.
Okay.
Thank you, Pete, for your patience.
Yep. All right. Yep. I appreciate you guys.
Yes, and thanks for all the members
Thank you.
being here. We really appreciate it.
Yep. Okay.
All right.
Meeting adjourned if there's no further questions.